Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Good afternoon and welcome to this month's Third Thursday webinar. Now before we get started, I'm going to take a moment to discuss the services Synergy offers to help trial lawyers do what they do best. We handle resolution of a variety of different lien types, and we have experts in every type of lien to ensure the best results for your client. We assist with Medicare compliance, helping you understand what your client needs to do to comply with the Medicare Secondary Payer Act. We also offer settlement consulting, including attendance at mediation, both over the phone and in person, as well as a team of people dedicated to creating structured settlements to help your client make the most of their recovery. We also offer trust administration services so that your client can keep their public benefits and get assistance managing their funds long term. And finally, we can help you defer your attorney fees as a tax saving strategy. So this month we're talking about ABLE accounts. Most of the trial attorneys and people with disabilities I speak with have no idea what ABLE accounts are. So it seemed fitting that we spend a little bit of time spreading awareness and talking about how these accounts work. I can tell you right now that this will not be the right solution for every case, and you may even struggle finding situations where it works well at all, but it's another option. For cases where ABLE accounts can be used, they can be very impactful, so it's definitely worth learning about. I also feel it worth noting that ABLE accounts are not something that Synergy offers. And while I will from time to time talk about what we do here at Synergy, this is really not a sales pitch. It is purely educational. We'll start with a little bit about me. My name is Evelynn Passino, and I am the Executive Director of Pooled Trust Solutions. I am an attorney, and I'm licensed here in Florida. I specialized in elder law in law school, and prior to my career in law, I was in the Medicare Advantage space for the better part of a decade. Pooled Trust Solutions is based here in Florida, but we serve clients all over the country to the tune of about 400 active trust sub-accounts. We have an amazing trust administration team who works with beneficiaries and their families every day. We administer pooled trusts for a variety of situations, including a pooled special needs trust for people with SSI or Medicaid. So this is what we're going to cover today. I'm going to start with a quick overview of public benefits. This is not a deep dive. We do have other webinars that go into public benefits if that's something you need to understand better. But I'm just going to cover the basics here because you will need some context to understand ABLE accounts. We'll spend the bulk of the presentation on the ABLE Act, ABLE accounts, how they work, the good, the bad, the ugly, and finally I'll talk about how an ABLE account can fit into a settlement plan, and then we'll have some time at the end for questions. First things first, public benefits. The first thing you need to know about public benefit programs is that they all have their own unique qualification requirements. For some programs, you need to be under 18 or over 65 or disabled or have a particular condition like ESRD or blindness. Many will also look at the resources that are available to the person. Something that people often get hung up on and use interchangeably is income and asset limitations. These don't actually mean the same thing. Some programs have income restrictions, some have asset restrictions, some have both, and some have neither. Any money or cash that's received, unless it's excluded by a particular rule or regulation, could be both income and an asset, depending on when you look at it. So the month when it's received, it's income. And then the next month, if you still have any of the money left, then that portion of the leftover becomes an asset. I have an example here that walks you through that. So say the client receives $100,000 at the beginning of June. In June, they have received $100,000 in income. plus whatever else they get. If they spend $30,000 in June and carry the remaining $70,000 to July, then in July they have a $70,000 asset. What this means is that if a benefit only considers income and they receive their settlement check outright, then they'll probably lose that benefit for 1 month, but then it'll come back. If, for example, they have a monthly annuity paying more than the benefit will allow, then they're going to lose that benefit every time they get an annuity payment. On the other hand, if the benefit only considers assets, then they'll be fine in the month of receipt, but any money they carry into subsequent months will cause them to lose the benefit. People sometimes think that because PI settlements are generally not taxable, that they're also not a accountable resource for public benefits purposes. And unfortunately, that's not the case, except for some HUD benefits. The majority of the benefit programs will count a settlement as a resource unless some kind of planning is done. It's also important to remember that public benefit programs are administered by federal, state, and local agencies. So that means the rules can change not just from state to state, but also from county to county in some places. The Social Security programs like SSI and SSDI and Medicare are pretty easy because they're federal, so they're going to be the same everywhere. But Medicaid and HUD, for example, vary from state to state and county from county and even from program to program. So the only way to know what rules actually apply to your client is to verify with the agency, which in some cases can be done over the phone, but always ask your client for their ID cards and their award letters. These letters will typically state what the resource restrictions are, so that's the easiest way to know. If your client has lost their letters, sometimes they can be obtained online, and I've provided a link here for the Social Security Administration's website where the client can make an account and verify their benefits. But you can also get to it by Googling SSA proof of benefits or something along those lines. Another thing to remember is that public benefits are always going to fall into one of two categories, means tested or entitlement. Means tested benefits are the ones with resource restrictions. So the main ones are Medicaid, SSI, SNAP, which used to be food stamps, and HUD and the other housing benefits like Section 8. Entitlement benefits are those without a resource test. So once a client earns this benefit, they aren't going to lose it because they have too much money. So this includes Medicare, SSDI, and Social Security retirement benefits. You may notice that I did not list veterans benefits, and that's because they can go either way. Some have a resource test and some don't. So you just have to look at the benefit to know. We get a lot of questions about SSI and SSDI and what the difference is. If your client says they have Social Security but they don't know which, one way you might be able to tell is to ask how much they're getting every month. If they're a single person getting more than $783 per month, then they don't have SSI, unless for some reason the state is supplementing the benefit. If they're getting less than $783, then they could have either. So again, the only way to know for sure is to verify the benefit with the SSA. So ask for the letter or have the client go online and get a copy of it themselves. So to keep these benefits, the client has to take some kind of action. If you just write them a check, they're probably going to lose their means tested benefits. They either need to spend the money or put it into some kind of an exempt account. There may be other options in your state. These are just the main ones that are available everywhere because they're based on federal law. But if these options don't work for your client, then definitely reach out to an attorney in your state who specializes in elder law or special needs law and see if they have any other suggestions. Keep in mind that virtually all benefits programs will not count the primary residence and one vehicle, meaning they don't count against the resource limit. Some programs are more generous and will allow multiple cars, and others are less generous and will put a cap on the value of those assets. Burial and funeral planning is also very popular, but many states will limit how much you can spend, so you have to understand what the limits are in your state. Debt can be very tricky. We often have clients who received help from a friend or a family member while their case was pending, and they want to pay that person back, and understandably so. Unfortunately, if there isn't much of a paper trail, and there usually isn't, then making a payment without a bona fide loan in writing can appear to the benefits agencies that a gift is being given. And unfortunately, gifting money will cause the benefits agency to apply a penalty, which is typically loss of the benefit for a period of time. So if the person doesn't want to spend their money, then they can put it into a special needs trust or an ABLE account. And that brings us to the ABLE Act. The problem the ABLE Act was trying to address is that people on public assistance programs have to keep their resources so low in order to keep qualifying for benefits. Many programs will limit income or resources at about $2,000, so that's often used as a rule of thumb, but it varies. And that means that in order to qualify, they either had to constantly spend down whatever money they did get or put it into a special needs trust, which could be undesirable for any number of reasons. Setting up a special needs trust is also not always practical. We'll talk more about how special needs trusts measure up against ABLE accounts later in the presentation, but if, for example, a person is working limited hours but still making enough that they can't qualify for their benefits, then they would never have enough money to justify creating a trust anyway, but they also wouldn't be able to save it. And basically, they would always be living month to month. So Congress wanted to give people a way to save money, grow that money, and still qualify for benefits. So the idea was to help people with disabilities be more independent and help them plan for their future at the same time. So in 2014, Congress passed the Stephen Beck Jr. Achieving a Better Life Experience Act, now known as the ABLE Act. And this law allowed states to create their own ABLE programs. While not every state has their own ABLE program, whatever state your client lives in, there is an ABLE program that they can join because some are available to residents of multiple states. Ohio's program, for example, is available to residents of all 50 states. To see a full list, I highly recommend going to the ABLE National Resource Center's website. There is a ton of good information there with breakdowns for every state. So here's what you need to know about ABLE accounts. First and foremost, these accounts are an exempt resource, so they're not counted by the Social Security Administration, Medicaid, or any of the other public benefits programs. All of these benefits programs have since released rules and regulations that specifically exempt ABLE accounts. Second, any deposits, disbursements, and income from the investments is not going to be taxed. The only thing the client has to do is make sure that they only use money in the ABLE account for qualified disability expenses, or QDEs. QDEs are basically anything that supports a client's disability. It's a very broad term, and that's how Congress intended it. QDEs even include basic living expenses like rent, utilities, and food. And the food doesn't even necessarily have to be tied to a medical need or a disability. Now, I mention this because it was an open question for a long time, but the Social Security Administration has since released rules reflecting the very broad nature of QDEs and specifically stating that food and rent are QDEs. So we don't have to worry about that anymore. Money in ABLE accounts is invested, and many of the programs have more than one portfolio to choose from. So a risk-averse client can choose a very conservative portfolio, and a client with more of an eye to growth can choose a more aggressive portfolio. One of the most important aspects of ABLE accounts is that they are completely controlled by the client. So the client decides what gets paid, what doesn't, as well as how and when those payments are made. So ultimately, they decide what a QDE is. But this choice is not without consequence because they could get audited by the IRS, although to my knowledge that has yet to happen. If it did happen, and assuming the person did use the money for something the IRS determined was not a QDE, then the IRS would assess a 10% penalty, and the money that was spent on the purchase would become taxable. The Social Security Administration could also inquire, and if they determined that the client took a distribution for something that was not a QDE, or if they held onto the money for too long, then they would count the distribution as income. So for those reasons, the client needs to be able to keep track of what they're spending, keep receipts, and document why they think something is a QDE, just in case they ever get asked. Now we'll move on to limitations associated with ABLE accounts, which are significant, and these things illustrate why ABLE accounts have not yet become a preferred method in settlement planning. I also believe these limitations are why so many people don't know about ABLE accounts, even in the disability space, and why they remain so underutilized in personal injury cases. The big limitation is age. So to create an ABLE account, you have to have experienced the onset of a disabling condition before turning age 26. To clarify, a person does not need to have a disability determination or even a formal diagnosis before turning 26. The condition just needed to be present. But since disabling injuries can happen at any age, this keeps a lot of people, including many of our clients, out of ABLE accounts. Keep in mind, though, that this is not something that ABLE providers actually check. They do not ask for proof, like medical records or a doctor's note or anything like that before opening the account. They only require that the person sign a statement under penalty of perjury attesting that they meet this requirement. The IRS, however, could do an audit and could ask the client to prove that they were disabled before age 26. So clients need to be prepared for that possibility. But again, I don't think this has actually happened to anyone yet. If you're wondering why it's age 26, I don't have a great answer. Most likely it was just to limit the impact of these accounts being tax deferred on the government. There are people who are working to try to get the age raised to 46 through the ABLE Age Adjustment Act, but it hasn't gotten a lot of traction yet, unfortunately. Finally, there are also some limits on how much you can put into an ABLE account and how much you can keep there. So there is an annual deposit limit of $15,000. This tracks with the annual gift tax exclusion, and it goes by calendar year. If the person is working, they can deposit another $12,140 from their wages for a total of $27,000. But again, this $15,000 limitation is what's going to keep most people with personal injury settlements away from getting to use an ABLE account for their entire settlement. There's also an account balance limit that varies by state. So this comes from the state's 529 plan limit. If the person has SSI, then there's another limitation. The money can accumulate, but it can't get past $100,000. And if it does, then the Social Security Administration will consider it a resource. To my knowledge, no one has hit either of those numbers, although I do know of one person who was able to accumulate enough money to buy a home. To further illustrate how ABLE accounts work, I'm going to do a comparison between ABLE accounts and first-party special needs trusts. I chose first-party trusts because that's what's typically used in personal injury cases. But if the client is going to be getting money from an inheritance or a fundraiser, then they would want to set up a third-party special needs trust as well, because that type of trust does not have a Medicaid payback provision, but that's a topic for another day. Setting up an ABLE account is very easy and can be done by the client and typically is done online. It literally only takes a few minutes. Trusts, on the other hand, are a completely different animal. A trust is a legal document, so you need to work with an attorney who specializes in that area, and it could take weeks or months to get set up. There's also the added cost of having the attorney draft the trust, which can cost in the $5,000 to $10,000 range. ABLE accounts also tend to be less expensive, not just in setup costs, but also in terms of minimums and annual fees. So they generally require a small amount to seed the account, and then they have a set annual fee after that. Some also have additional fees for other services that they provide. Trusts, on the other hand, can require a very large minimum of funding, depending on the trustee and the asset manager that are involved. There are also trustee and asset manager fees, which vary, but typically they're a percentage of the assets, plus fees for additional services that are provided throughout trust administration. ABLE accounts can take funding from any source, so long as the total doesn't exceed $15,000 for the year, whereas a first-party trust can only accept the client's money, which is why they're typically used in personal injury cases. We've already talked about QDEs, but these are very broad compared to a special needs trust. So special needs trusts have a sole benefit rule, and technically ABLE accounts do too, they just don't call it that. But in the trust administration world, sole benefit just means that the disbursement has to be for the primary benefit of the beneficiary. One area where ABLE accounts and special needs trusts differ is that with an ABLE account, the client can actually transfer money out of the ABLE account and into their own personal bank account, so long as they use the money for a QDE. Special needs trusts just can't do that. They can't ever give money directly to the client, either by cash or by check, because it would be counted as income automatically. Something to understand about special needs trusts is that they are meant to supplement and not replace benefits. So a special needs trust trustee should not disperse funds for anything that another benefit could pay for, unless it's in the client's best interest to do so anyway. So for example, The SSI check is meant to cover food and shelter expenses. So if a special needs trust disperses funds for rent, for example, then the person's SSI check is going to be automatically reduced by up to a third of the federal benefit rate, which in 2020 is $261. But sometimes it makes sense to do that. So a person shouldn't have $1 million in their trust, but live in poverty because they're going to lose $261 if they use their special needs trust to pay for rent. But the point is that there is a consequence if the special needs trust pays for those things. Whereas ABLE accounts, on the other hand, can be used for food and shelter expenses, as I've mentioned. For this reason, the two can work together. So what typically happens is the bulk of the settlement will go into the special needs trust, and then the trustee can put money into the ABLE account as needed, and the client can use it for food, rent, and utilities. Another example where they differ is in medical marijuana. So because, as we all know, there's still a federal prohibition on marijuana, and because some of the public benefit programs are federal, a lot of special needs trust trustees are not comfortable dispersing funds for this purpose. An ABLE account, on the other hand, certainly could be used for this because the client is making the decision. However, I would advise your clients and strongly recommend that they only do this if they have a prescription or if they have a real medical need. Otherwise, it could be hard to argue that it was in fact a qualified disability expense. Another area where these two differ is on who the decision maker is. So as we've discussed with ABLE accounts, it's the client. With the special needs trust, it's the trustee. And this can be a big sticking point for a lot of clients. They have to be comfortable with giving up control of their money, and that can be very difficult for people. Trustees have a fiduciary responsibility to make decisions in the best interest of the beneficiary, but reasonable minds can disagree about what that means, and beneficiaries certainly disagree with their trustees about this all the time. That said, there is some degree of protection for the beneficiary when the trustee is the one making decisions. I'm not trying to say that trustees know better or anything like that, but if the trustee makes a mistake, then there is an argument to be made that the beneficiary shouldn't be punished by losing their benefits. So the client might love the idea of having control over their ABLE account, but they aren't totally free from consequences if they mess it up. Even though, to my knowledge, no one has been penalized with regard to improper use of an ABLE account, and there are certainly those who feel that ABLE account penalties, as they are right now, are not severe enough to have to worry about. There are consequences, so that's something to keep in mind. In terms of access to the funds, the options are largely the same. So for both ABLE accounts and special needs trusts, they can make distributions by check, wire, debit card, etc. And many trustees, at least in the pooled trust world, are now offering a TrueLink card. If you're not familiar, the TrueLink card is a prepaid managed debit card that the client can use to make in-person purchases using the money in their trust. Some ABLE accounts are now offering TrueLink cards as well, which makes them that much more convenient to use. If the client dies and there's still money in their ABLE account, then what happens next depends on the state. So in some states, Medicaid is automatically paid back from the account. In other states, the money first goes to the person's estate. Now, Medicaid estate recovery would still apply, but then arguments can be made that the money should not go to Medicaid rather than it going directly there. Now, with special needs trusts, it depends on what type of special needs trust is used. So with a standalone special needs trust, the money is automatically used to pay back Medicaid for any services that Medicaid provided. If there is money left over after Medicaid payback, then it can go to the beneficiary's estate or to their designated remainder beneficiaries. If a pooled special needs trust is used, then the nonprofit trustee may retain some or all of the funds as well. Each pooled trust has their own policy on this, so you have to check the language of the trust in the joinder to know what the process will be when the person dies. And finally, if the client fully recovers and is no longer disabled, then the ABLE account can stay open, but it's going to lose its tax-free status at the end of that calendar year. A special needs trust can be terminated, but Medicaid has to be paid back first, as if the person had died. So the special needs trust can still stay open as a support trust. So we have now reached the most important question, and the reason I assume you're all still listening, and that is, what does all of this mean for settlement planning? So if it's a very small settlement and the net is under $15,000, then consider using an ABLE account by itself. You could set up a trust, but the setup cost might make that an unattractive option. If you do recommend your client set up an ABLE account, then make sure they understand the basic rules and what the penalties are. Again, they need to be capable of managing the account. They need to be organized. They need to be able to make reasonable, justifiable decisions for what a qualified disability expense is. They need to be able to illustrate that to the IRS if they get asked. And they need to be able to keep receipts. So they need to have those basic organizational and record keeping skills. If you don't think the client can handle that, or they don't qualify for an ABLE account, and they truly have nothing else that they need to spend the money on, then look for a pooled trust. Most of them will accommodate smaller settlements. Pooled trusts can also help with care management and coordination of benefits. So if your client is going to need some help managing their money and adjusting to post-settlement life, then I would strongly consider working with a pooled trust. Now, if the settlement is over $15,000, then we recommend funding a special needs trust and then setting up an ABLE account if your client will benefit from it. So if they qualify and if they have SSI, then this makes a lot of sense just because of the ability to pay for food and shelter expenses out of that ABLE account, which they would not be able to do out of the special needs trust without having an impact on their SSI check. But if you do this, make sure that the trustee knows ahead of time that the client is interested in having distributions go to an ABLE account. And there are a couple of reasons why. One is that if a trust is being drafted from scratch, then the attorney should include a provision expressly allowing the trustee to fund an ABLE account. And second, because trustees do not all agree on the topic of funding ABLE accounts. So because ABLE accounts are still relatively new and there's not a lot of litigation about them, and there are more rules and regulations, but still not as much as we really need, we don't totally know what the bounds are of what's acceptable and what isn't. So some trustees are comfortable making a $15,000 disbursement on January 1st, and others feel like it's better to parse the money out by quarter or by month. On the other hand, some will treat a disbursement to an ABLE account just like any other disbursement from special needs trusts. So they might require a lot of documentation about it. They might even want the client to send receipts every time they make a purchase from the ABLE account so that the trustee can verify how the funds were used. Good trustees will identify cases where ABLE accounts could be helpful, but it's definitely easier if this is discussed beforehand just to make sure that everyone is on the same page and comfortable with what the trustee's policy is going to be. Throughout this presentation, you may have had the idea of funding an ABLE account with a structured settlement. I mean, why bother with a special needs trust when you could just set up an annuity to pay out $15,000 per year? And that's a really great question, but there are some risks associated with doing it with that way, mainly because it isn't expressly allowed or prohibited. The closest that we have is a provision on ABLE accounts in the POMS, which, if you're not familiar with that, is the Social Security Administration's rule book that we have to follow. And it says that direct deposits to ABLE accounts are counted as income as they would normally be counted if they were received by the person. So basically it's saying that you can't avoid a payment being counted just by using direct deposit. So that leads us to believe that Social Security might treat that payment like the person received it themselves, even if it's going, the check is going directly to the ABLE account. So that means they might count it as income. And there are some arguments against this. You could argue that a structure payment is not the same as direct deposit, or that structure payments are not covered by the rule. So that particular POMS provision also has a list of example payments where they say these are the things that we think would count, and structured settlements and annuities are not listed there. But the point is we don't really know, so it's a risk. There's also the risk that the limitations associated with ABLE accounts or the accountability rules may change at some point, while the annuity is going to be virtually set in stone. So it's not likely that that $15,000 limit is ever going to go down, but it is possible. And, again, since there aren't a lot of rules about ABLE accounts, the rules could change or new rules could be put in place that make this prohibitive. The bigger risk is that the client will inadvertently exceed the annual limit themselves. So if, for example, you set up an annual payment of $15,000 to go to the ABLE account, and the day before the check arrives, the client deposits $1 into the ABLE account, when that $15,000 check arrives, it's going to be rejected. There's nothing that they can do with it except send it back. And that's kind of an extreme example, but even if you had payments flowing in quarterly and midway through the year, the client received an unexpected gift or maybe a small inheritance, and they put that money into their ABLE account, then they could create a situation where that last check can be deposited. So for all those reasons, we recommend having the structure payments flow into a special needs trust and then working with a trustee who is comfortable funding the ABLE account. And if you do it that way, then you don't have to worry about any of the issues that I've already talked about, and there will be flexibility down the road. So that's the end of the main part of the presentation. I hope you learned something that you can use next time you're working on a recovery for someone with government benefits. As you have seen, ABLE accounts are not for everyone. Unfortunately, there are a lot of people who just don't qualify, usually because of the age restriction. But when they do work, they can give the client more flexibility and independence with their money, and those things cannot be underestimated. We believe, like all of you, that this money should be used to improve the life of the beneficiary. And while the benefits rules can make that difficult or make it more complicated, we're going to do everything that we can. All right, so we've got a few questions to start with. So I'm going to start with these, but if you have more questions, feel free to put them in the chat box and I'll address them as they come in. Also, if you happen to join us late, or if you just want to hear this presentation again, it will get uploaded on Synergy's YouTube page, so feel free to check it out there as well. So the first question we have is, can I set up an ABLE account for my client? And the answer to this is yes, you can, if you have the legal authority to do so. So an ABLE account is kind of like setting up a bank account. So you have to have some kind of legal authority like a power of attorney to do so. And I'm not sure if all ABLE accounts do this, but I do know that the Stable program, which is the one out of Ohio, actually has on their website a sample limited power of attorney form. So if the client, wants to have parent or a friend set it up, they can just download that form and it's going to give that person the very limited authority to just set up the ABLE account for them. So that's very convenient. All right, next question is, could my client create multiple ABLE accounts? So unfortunately, no. Under the ABLE Act, you can only have one account open at a time. But a person can transfer ABLE accounts. So, if say they sign up with an ABLE account and they sign up with a particular program and decide they don't like it, maybe they're not getting good customer service, or maybe there's a different program that has, better benefits that they want to take advantage of, or, a different portfolio to invest in. They can transfer. So they just need to look at what the rules are, with both ABLE accounts and just make sure that that's all handled by them, but they can move between accounts. They just can't ever have two open at the same time. Right. Next question is, does my client need to be getting benefits currently in order to set up an ABLE account? Not necessarily. So I'm not really sure why they would want this if they didn't actually have those benefits, but I guess you could be trying to set up or trying to get qualified for benefits. So you might want to set up an ABLE account to put that money aside and not have it count against the resources. So if they aren't already qualified for one of those benefits like SSI or Medicaid, the ones that require a person to be disabled, then it might be kind of hard to argue that they are in fact disabled. But they don't necessarily have to be getting those benefits. They don't actually have to have a Social Security determination of disability or anything like that. What the statute actually requires is that they have to have a marked and severe functional limitation. And that condition has to last at least 12 months or it has to result in death, or be reasonably expected to result in death. So, if the client doesn't actually have medical records to support that currently, then that's something that they should go to a doctor and try to get some kind of a disability certification or letter from a doctor just to keep that in their files. So something I talked about in the presentation is that ABLE accounts typically are not asking for this. They're not asking for medical records or any kind of proof, but they certainly could. They could do that in the future, or there may be programs out there that I haven't personally worked with but are doing that. And the IRS absolutely could come back at some point and say, hey, we want to make sure that you're actually qualified to have this account. So I strongly recommend that if the client doesn't already have that kind of documentation, that they get that together before they actually establish the account, just to make sure they have it. All right, next question is, can someone with an ABLE account, or I'm sorry, can someone open an ABLE account at their bank? This is a really great question, but unfortunately, no, at this point they can't. So basically you have to go through one of the state approved programs that does ABLE accounts. And like I said, there is a list of those on the ABLE National Resource Center's website. So the ABLE NRC has a list of all of them. On a related note, I mentioned in the presentation that typically these are open online, and some of them will let you open the account through paper or manage it on paper, but that's actually pretty rare. Most of them are 100% online. And that's because if they are forcing you to use the account online, it doesn't really make sense to let you sign up for it on paper because you're going to have some kind of computer access at some point. So most of them just do it that way. But while I was preparing for this presentation, there was one that I came across that does allow you to both sign up with a paper application and manage the account, like put in disbursement requests and those kinds of things all on paper. And that is ABLE for All. And I think they're available everywhere. So if you have a client who is just really not tech savvy and wants to be able to send their forms in, that's something they could definitely check out. Unfortunately, I don't think that any of them actually have like in-person places that you can go, like a freestanding location, like a bank. Everything has to be done remotely, which in the era of COVID is preferable. But I know that some people just prefer to have a place to go, and I don't think any ABLE accounts actually have like a location, like a brick and mortar location. But they do all have phone numbers, so that's typically how our clients are working with them. All right, next question. So how do people add money to their ABLE accounts? And does it have to be by check? So it doesn't have to be by check. They all take check, but a lot of them now are allowing electronic funds transfers, ACH transfers, things like that. One of the cool things that's happening right now is with ABLE for All, they're actually allowing people to set up like a gifting page, which is sort of like a fundraising or crowdsourcing page, kind of like you'd see with a GoFundMe. And then, they can post that out on social media, and then, people can actually just donate straight to their ABLE account, which is really nice. The only risk with that is, like we talked about, there's that $15,000 limit per year. So, there's a risk that if someone is getting money later in the year, that they, potentially are going to create issues there. But fortunately with the ABLE for All one, they actually have like a limit on it. So like if you're getting money later in the year, you can actually say, I only want people to be able to donate up to X amount of dollars, and then they won't actually be able to exceed that limit. And Stable, which is another one I talked about, they have something that's kind of similar, but it's more email based. Okay, next question is a little bit long, so I'm just trying to read it. So if a client receives a settlement of $17,500 and the ABLE account has a cap of $15,000, can they still receive the balance of $2,500 if that is what their state would normally allow if they did not have the ABLE account? And can we send one check and have them responsible for depositing the $15,000 into their ABLE account? So the second part of that question is a little bit easier to answer. You could send them the check and have them deposit it. The issue that I see with that is that them like taking control of it that's definitely going to look like they had income. So, you could do it that way, but it's probably going to impact their benefits for that 1 month. And then the first part of the question is, if they're receiving more than $15,000, can they put that $15,000 in their ABLE account and then just, take the rest of it in cash? Yes, they definitely could do that. I mean, you want to be aware of what the limits are for them. With $2,500 is probably going to exceed a lot of the Medicaid limits that I'm aware of, but not necessarily. So it also is a lot easier to spend down $2,500 than it is to spend down $15,000. So, we have clients that come to us in the special needs trust context sometimes who they're getting, whatever amount of money and they just don't have anywhere to spend it, but they don't really have enough to set up a special needs trust. So I think this is kind of a good example of that type of situation where, someone has a little over 15,000, they can put that 15,000 in the ABLE account and then take the rest of it. And even if that amount is over whatever their Medicaid limit is, they still, they can probably get rid of $2,500 within the month, by buying something for their house or, that kind of thing. So that's a really good question. Second question, or I'm sorry, next question. So if funds are already distributed to the client, can you set it up months later and avoid long ineligibility periods for public benefits? So this one's hard to answer without more detail. So you can set it up at any time. So if the person got their money and they're still in a period of ineligibility and, it depends on, I guess, what penalty is being assessed against them. But if all they need to do is put that money into a place where it's no longer countable, then an ABLE account is definitely an option for doing that. If they have like a penalty for gifting, for example, those penalties are typically based on the amount that was already gifted. So getting rid of money now isn't necessarily going to help them, but that's kind of the gist of how that would work. All right, next question. If a client is on an entitlement benefit like SSDI, do ABLE accounts provide any kind of benefit to them? So it wouldn't provide the benefit of allowing them to continue to be eligible for their benefits because SSDI doesn't have any kind of an income or asset limitation. But they still would get the benefit of being able to save that money tax-free, have it grow, have it be invested, have an easy way for people to donate to their account if they want to do some kind of fundraising. So there are still some benefits out there, but they wouldn't be getting the main one, which is that it's a non-countable resource. All right, next question. If we were to transfer $15,000 from our trust account to the ABLE account and the balance, for example, $500 directly to the client, would SSA consider the full amount of $15,500 as income to the client in that month? So I don't think so. I think if it goes from a trust account to an ABLE account, that $15,000 is not going to be counted because that's fine. There are provisions, I know specifically in the POMS, allowing trusts to make disbursements to ABLE accounts. So there's no reason why they would count that as income. So I think in that case, they would only count the $500 that's going directly to the client. Okay, let's see, looks like we've got one more. So if there's any more, feel free to send them, but otherwise this will be the last one. So finally, can my client buy a car with their ABLE account? So yes, so buying a vehicle and any related costs like upkeep and insurance and those kinds of things, those are all qualified disability expenses. The only thing they would want to worry about is making sure that that vehicle is still an exempt resource for their other benefits or whatever benefits that they have. So, most of the Medicaid programs, and I want to say all of them, I just don't know for sure that's all of them, but I'm pretty sure all of the programs exempt at least one vehicle. So, but if say the client already had a car and then they bought a second car with their ABLE account and they didn't get rid of that car, and then they had two cars, then that would cause an issue. I know that would cause an issue for SSI, probably would cause an issue for Medicaid, just depending on the state. So, it wouldn't necessarily be a problem for the ABLE account, but still something that they would want to think about. And something else that, I guess kind of a related question in my mind to this is, does it have to be a particular type of car? And I think definitely a car that has some kind of accessibility features, definitely is going to be a qualified disability expense, like no question. Um, but it doesn't necessarily have to be that. It doesn't have to be like a wheelchair accessible van. I think it's totally reasonable to argue that, a car that you just use to get back and forth to the doctor's office, like that would be a QDE in my mind. So I think you, you probably have a harder time arguing that with like a luxury brand, but um, but again, one of the things I talked about in the presentation is that there hasn't been a whole lot of oversight about, how these able accounts are being used, and whether these things are QDEs, and uh, so I mean, who knows? It could work, but this could also change in the future. It's one of those things that is very much evolving. So certainly I don't want to imply that there are no rules and no one should care about them, but at this point we're not seeing that kind of enforcement. So it looks like that's my final question. So thank you so much for joining, and have a great rest of your day.